Well, joining us now from Brisbane to discuss the political developments of the last 2 days is Shadow Attorney General George Brandis. Senator Brandis, welcome to the program.
Hello, Ali.
On what grounds do you make the claim, as you have, that this week's High Court judgment, quote, does not affect the legality of the use of Nauru as an offshore processing centre?
It's very straightforwardly. The basis on which offshore processing is allowed under the Migration Act is a section introduced by the Howard government in 2001, section 198A. That section was not struck down by the High Court on Wednesday. Indeed, its validity wasn't even challenged by the plaintiffs. The case turned on the question of whether or not the minister was at liberty to satisfy himself of the matters he needed to be satisfied of under that section by reference to the domestic law of Malaysia. And the court decided 6-1 that because Malaysian law, domestic law, lacked the protections that section 198A required the minister to be satisfied of the existence of, his declaration was affected by what lawyers call jurisdictional error.
But given the advice of many constitutional lawyers against that background, and given the fact that Nauru has never actually been challenged in the courts, how can you be so confident that it wouldn't be, should it be reopened?
Well, it all depends what proposition you're asking me to dispute. But anyone who says that the result of the decision of the High Court on Wednesday was that offshore processing in all circumstances is no longer available to the Australian government is misrepresenting the effect of the plain language of the judgment of the majority. But
it doesn't necessarily mean the opposite either, does it? I mean, this judgment doesn't mean that offshore processing in places like Nauru are going to be upheld under the legislation, that it would in fact pass muster under the Migration Act.
Well, what it means, Ali, is that for there to be offshore processing, the minister would have to be satisfied of the matters set out in section 198A of the Migration Act. It was because the minister couldn't have been validly satisfied of them in relation to Malaysia that his declaration was struck down. Now, that depends in turn on whether the domestic law of the third country contains a sufficient measure of protection so that the minister could be satisfied of those matters. And this has never been problematic with Nauru, particularly, I might say, and the High Court emphasised this. The Australian government itself superintends the processing centre on Nauru. And as recently as yesterday, the Nauruan Justice Minister announced that his government was examining the High Court decision. Nauru, as you know, is keen for this processing centre to be reopened. And he said that if there were any changes to the domestic law of Nauru that were needed to be made in order to bring its law into conformity with what the High Court required and section 198A of the Australian Migration Act required, then his government would make those changes.
But given that, I guess, if the government was to switch to Nauru, would you support a sort of pilot project, if I could put it that way, so that it could be legally tested before hundreds of millions of dollars were spent getting the facility up and running completely?
Well, I don't think we need to engage in pilot projects. The fact is that it hasn't been suggested, it's not been suggested in any piece of litigation that the Nauru solution was not valid. In fact, 198A of the Migration Act was introduced by the Howard government for the express purpose of facilitating the Pacific solution.
But I go back to the point that it has never been tested. Would the Coalition support an amendment to the Migration Act if it proved to be the case that under section 198A, as it's now being interpreted, no country would meet the criteria?
Well, that's just a false premise, Ali. It hasn't been interpreted to say that no country would meet the criteria, and anybody who makes that claim is misrepresenting the effect of what the High Court decided. In my view, there is no reason to believe that Nauru is incapable of satisfying the criteria in the Act, and if it is, then the reasons for judgment that the High Court delivered on Wednesday simply don't apply to that country.
You criticised the Prime Minister for her comments regarding the High Court. How is it any different to the comments, and I'm just choosing an example here, but of Philip Ruddock, the former Attorney General in 1998, when he said that, again, the courts have reinterpreted and rewritten Australian law, ignoring the sovereignty of Parliament and the will of the Australian people?
Well, I'm not familiar with that particular remark of Mr Ruddock's, but let me just make the point that it is a fundamental principle of our Constitution that the political arms of government accept the finality of adjudication by the High Court. And the basis of my criticism of the Prime Minister was that although, of course, every citizen is entitled to have a discussion about the consequences of a High Court decision, she went further. She went a critical stage further. She suggested the High Court got it wrong and there was something wrong with or dubious about the decision, in particular with her extraordinary ad hominem attack on the Chief Justice. Now, that is a fundamental departure from everyone's understanding of the separation of powers, that, and in particular, once the High Court makes its decision, then the government of the day, whether it likes it or not, must accept it.
That said, the Prime Minister argues she was simply stating the facts. As she stated in those comments, the High Court Chief Justice Robert French had made a different decision at an earlier point in his career. That is a fact. Well, as a matter of fact, it's not a fact, and this is another assertion by the Prime Minister that is wrong. I've looked at the previous decisions that, and in particular there was one decision, a case called P1 in 2003, in which Justice French, then a judge of the Federal Court of Australia, was asked to look at Section 198A. And the facts of that case and the basis upon which that case turned were entirely different from the issue that was presented to him in last Wednesday's decision. So the Prime Minister's assertion that the Chief Justice was being inconsistent was itself wrong. The previous occasion on which Justice French considered Section 198A didn't raise the issue of jurisdictional error. And he specifically said in his reasons for judgment that I read only this afternoon that different considerations in that case would apply if jurisdictional error were an issue. The decision on Wednesday turned on the question of jurisdictional error. So the Prime Minister's assertion of inconsistency was itself wrong. Do you think Tony Abbott will be facing Julia Gillard at the next election?
Look, I know that Tony Abbott will be facing somebody who it will be is really the Labor Party's problem, Ali.
You wouldn't like to place a bet there?
No, look, I really think that this is a matter that the Labor Party needs to work out for themselves. The government at the moment is obviously not performing as people would expect an Australian government should. The Prime Minister, including by the artless remarks she made about the Chief Justice, is not behaving the way a Prime Minister should. And I think, frankly, we have a crisis of confidence in this government now, which ultimately can only be resolved, as Tony Abbott has been saying all along, by an election.
Senator George Brandis, many thanks for talking to Lateline tonight.
Thank you, Ali.